So the Illinois Supreme Court, they gave a ruling yesterday concerning the Illinois Firearm Owner ID card and the Freedom of Information Act. Here's the headline. Illinois Supreme Court rules FOIA of FOID information not allowed. This happened yesterday, shortly after we got done with our broadcast. And if you recall, we did talk about this case when it was heard back in September. And that's, of course, Supreme Court Chief Justice Mary Jane Teese during Supreme Court oral arguments. And this case really, it stemmed around the idea of should you as an individual who is looking to get information about your FOID card being suspended or revoked, should you be able to get that information about yourself via the Freedom of Information Act, right? The Freedom of Information Act is a law that requires government bodies paid for by you, the taxpayer, to turn over public records. Now, there are some exemptions that are carved out in law, and each state really does have the ability to kind of craft their own law when it comes to what you can access via public records. For instance, I put a lot of public records requests in myself, could always do more. But there's a fine art there. You have to know kind of specifically what you're looking for, but cast a general enough net to be able to get stuff you might not know you were looking for. So there's a certain art and a craft to FOIA. But when it comes to you looking for information on yourself, you would think you should be able to have that ability. Well, this case came in front of the Illinois Supreme Court and involved two individuals who were looking to file Freedom of Information Act requests, or who had filed Freedom of Information Act requests with Illinois State Police to get access to their personal individual information. There's some interesting debates that could be had about this. Should they have known that if it's released by FOIA, it's publicly available to anybody? And I don't know if people understand that part about FOIA. There are some governmental bodies that have running lists of FOIA requests and the responses to those requests. And anybody can open that page up and find those links. Not every governmental body does that. Those that do, it's pretty fascinating because you could spend all day and find all kinds of pretty incredible information. But regardless, FOIA requests are FOIA-able. So if you as an individual are looking to get that information through the Freedom of Information Act and it's approved and they release that individual information about yourself, then that could possibly be accessible through another Freedom of Information Act request. So there's some interesting kind of loopholes that you want to make sure are closed, especially when it comes to your own personal information. So let's flash back just to some of the arguments from when this was heard by the Illinois Supreme Court back in September, with two individuals trying to get information about why their FOID card was either denied or revoked. And when you are in Illinois, you have to have a firearm owner identification card in order to exercise your Second Amendment right to keep and bear arms. It's challenged in the courts in both the federal and state level on the constitutionality of it, but this is a different case. This deals with whether or not you can have access to the rationale behind why you were denied or had a card delayed. Interesting arguments, but you had a couple of people who were wanting to get their personal information, so maybe they could better appeal to get their FOID card in place. And this is kind of how some of those arguments played out with the attorney representing the state laying out why they think that the plaintiffs suing the state because they couldn't access their Freedom of Information Act requests FOID information. So here's the state defending what they say is the importance of keeping private information private.
And it is clear that the General Assembly did not intend to include an exception in. And it is clear that the General Assembly did not intend to include an exception of any kind in that prohibition, because not only in the same provision, but in the very same sentence, the General Assembly explicitly allowed for an exception for information of applicants for a concealed carry license. Under the basic principles of statutory construction, that omission has meaning. And that clear, unequivocal language should have been the end of the inquiry. The inquiry should have ended not only because the provision's language is so exceptionally clear, but because, as ISP pointed out during the circuit court hearing in Mr. Burgess's case, that the way to get a copy of your application or denial letter is not by making a FOIA demand of ISP's FOIA officer, but to contact the Firearm Services Bureau directly. No one is trying to keep people's personal applications or denial letters a secret from them. But the Firearm Services Bureau needs to be able to verify that you are who you say you are before releasing copies of your confidential information.
So
And
ultimately,
the
the
Bureau will ask
argument
people to provide proof of
the
identity.
argument is that there are different avenues to go. So these were arguments made back in September, right? Whenever the Illinois Supreme Court heard this case of individuals trying to get their personal private information through the Freedom of Information Act. Maybe they felt that they just weren't getting the information in a timely manner. They wanted to appeal to this new board that's created for FOID appeals, and they want to get that process because they have a right to keep and bear arms, but they feel that their rights being withheld inappropriately. And that could be some of the sentiment behind wanting to get your records as soon as possible within that 5 to 10 day window that the Freedom of Information Act requires. So some of the questions that were brought up to Thomas Magg, who is the attorney for one of the plaintiffs in this group here in front of the Illinois Supreme Court back in September, dealt with that idea of different channels to be able to go through to get private information about your FOID application instead of going through the Freedom of Information Act request. Here is Supreme Court Justice Joy Cunningham asking Magg about that very question.
Response to the assertion that FOIA was the incorrect vehicle for seeking this information and that there was another appropriate vehicle that is in place for the parties to get this information without using FOIA.
It's obvious that counsel has never tried to get any documents out of the State Police Firearm Services Bureau. In some, they don't answer the telephone for hours at a time. They don't answer emails for days and/or weeks at a time. I mean, I invite this court to go to their website and dial the telephone number and see how many hours it takes to get a person, if you even can.
Obviously, all of this is way beyond the record.
That was what my next point was going to be.
That's Chief Justice Mary Ann Teese.
Talking about things that are
Mary Jane Teese.
the record. But if asked, I'm doing my best to answer the court's questions.
So, can you respond to the argument that Section 2, C5 specifically controls here, that identifies what private information is, and so therefore that is the kind of information that is not discoverable under the Freedom of Information Act?
Okay. What is private information is not, well, it may well include names, addresses, that type of thing. But that's not what we're seeking here. Quite frankly, we don't care if the state redacts my own client's names from my own client's record. That's not what we're trying to get here. What we're trying to get here, as counsel made reference to government action, we're trying to get to what the government's stated reason was for revoking, suspending, otherwise invalidating my client's FOID cards.
So again, that's the chief argument here. His clients are looking to get that information from Illinois State Police, and they apparently couldn't get it in a timely fashion as a way to try to challenge a suspension or a revocation or denial or whatever the case may be. It's not trying to get that personal information about their home address. It's trying to find out what the government action is. And that's really what the Freedom of Information Act is built to do, is to build to show you what the government action is. But the Chief Justice of the Illinois Supreme Court, Mary Jane Teese, she had another question that Attorney Thomas Magg had to respond to.
And we're debating what these words mean, where it's specifically there are certain documents that cannot be inspected and copied under FOIA. Another piece of it, of the same statutes, has an exception that can be, where information can be revealed, and that's under the databases under the Firearms Concealed Carry Act, records of the Concealed Carry Act Licensing Review Board under the Firearm Concealed Carry Act, and law enforcement agency objections under the Firearm Concealed Carry Act. So you say that that doesn't work very well, but that's not what we're talking about. We're saying this is what the language says.
Well, if you want,
this is not, these documents are not subject to FOIA, can't be inspected or copied but there are other avenues where people can get information.
Well, if you want to get ultra technical, unless otherwise authorized by the Firearm Concealed Carry Act, if you go to the Firearm Concealed Carry Act, it expressly authorizes the release of denials and revocations of concealed carry licenses, which are, at least at this point, printed on FOID cards. So if you want to get ultra technical, that's an authorization under the Firearm Concealed Carry Act. But I don't think you get that far because we're not seeking information of people, we're seeking information of why the state acted for the persons who they acted against.
So ultimately, those are the arguments that were made back in September. The Illinois Supreme Court, regardless of it having a composition of more Democrats than Republicans, were unanimous in denying somebody being able to go get their FOID denial information on themselves through the Freedom of Information Act, even if they consent to disclosing that information. The Illinois Supreme Court released that ruling yesterday. So fascinating stuff. Another story also that they released was the case was about the Biometric Information Privacy Act. If you're not familiar with this, BIPA, it of course was a measure that was passed years ago and is supposed to protect workers or individuals from having their face scanned without their permission or their fingerprint used without their permission. You've seen the Facebook settlements and even White Castle's facing a daunting settlement possibly after workers successfully sued that burger joint for requiring fingerprints for the workplace. So regardless of where you stand on the issue, it's been very contentious in the courts, and healthcare workers were suing hospital systems for requiring that they use their fingerprint to access cabinets with secured, scheduled drugs. And they sued using BIPA in state courts, got all the way up to the Illinois Supreme Court. They argued that their rights are being violated, but the hospital systems say that, well, it's all protected under the Health Insurance Portability and Accountability Act. I think it is HIPAA. But regardless, Supreme Court yesterday released a unanimous ruling saying that the hospitals are in the clear because that information is protected by HIPAA. So BIPA can't supersede HIPAA. Another Illinois Supreme Court case that we wanted to follow up on with you. All right, so those are just some of the things happening there. We've got tons more to get to, guys, from the Illinois Supreme Court all the way to the U.S. Supreme Court. We had this news come out yesterday, and we're going to get even more from this. And pretty exciting stuff for those of you who've been following the gun and magazine ban all this time, and all of the different ins and outs that we've had to watch happen throughout. But here is Dudley Brown from the National Firearms Group that is helping sue the state and city of Naperville. Here's his announcement from yesterday.
Breaking news, we just got word that Supreme Court Justice Amy Coney Barrett asked the state of Illinois for a response on our emergency appeal on the Illinois assault weapons ban. That means it's quite possible that the Supreme Court could intervene in that case and demand that they accept Bruin. That's what we're hoping for. We hope you're praying and crossing your fingers.
So we'll talk with Hannah Hill, and also Robert Beavis will be on the line as well with the National Association for Gun Rights and Law Weapons taking their case again to the U.S. Supreme Court. So that conversation's next here, all right? Appreciate everybody